Welcome back to our Bridge City News special report on Indigenous land rights. When it comes to stories involving Indigenous land claims, British Columbia is front and center. Landowners in Richmond, BC are unsure if they own their land after the BC Supreme Court recognized the Cowichan Nation's Aboriginal title, which is over 7.5 square kilometers of land there. And in February of this year, the legal waters got even muddier with the agreement between Musqueam Indian Band and the federal government. It raises the question, who owns what? Queen's University law professor Bruce Pardy was recently at the University of Lethbridge for a talk called The Property Peril: How Liberty Becomes Tyranny in the 21st Century. Our news director, Rod Kurtz, attended the event and then sat down with Bruce in our studios to discuss. Take a look.
So I sat in on this talk at the U of L. It was fascinating and frankly a little daunting, listening to your address and the ensuing discussion, and it's really not really sure where to start, but let's do this. You say property is not a thing, it's a right, and it's related to our freedom.
Yes.
Maybe explain that combination of rights, freedom, and property.
Sure. So if you are a free person, meaning that you are not subject to coercion of other people or by the state, then property follows as a result of that. Property is a reflection of the freedom that you have. If you are a free person, then you are able to own property. And if you own property, then you are the one to determine what happens with it. People who own homes in Canada, I think, expect reasonably that that property interest they have is secure. But what has happened recently, as you referred to, is that that question is now up in the air. People refer to their land, their house, their car, their stuff as their property. That's common parlance, right?
Yeah.
But what we're actually talking about is a category of legal right. So if you own a house, that means you have certain rights to exclude people and so on from the property, to sell it and to lease it and so on. So properly speaking, when we're talking about property, we're talking about legal rights, and that is the core of where you find out if your rights are secure or not.
I love the analogy you used in your talk when you talked about first-year law students. When they come in and you always ask them, first thing is, what do you think property is?
Right.
And they think it's their stuff.
They think it's their stuff, and it's a reasonable assumption, right? Because we talk about it this way. I bought a property down by the river, but everybody knows what you mean. But the actual what you're actually buying and selling are the rights to it. So just for example, if you own a house and you lease it out, what's actually happened is you've transferred property rights to your tenant. You've transferred occupancy or possession to the house, to the tenant, and the tenant is now the one with the right to exclude from that property. So it's a very interesting area of the law.
Okay, so what do we own though? Because do we own the land or we don't own the land?
You own an estate in the land, and that's a slightly different thing. We still have the remnants of a feudal system of landholding established after William the Conqueror conquered England in 1066. And a feudal pyramid is a very elaborate thing. It starts with the king at the top, and there are layers in the middle with the
lords,
noblemen, the lords, the barons, the knights, and then at the bottom are the serfs. The serfs who are actually on the land, working the land. And what has happened over time is that those middle layers of the feudal pyramid have disappeared, but the serfs are still at the bottom, and that's us. We own a thing called a fee simple.
Right.
We don't own the land, we own an estate in land. It's called a fee simple. It's an inheritable estate, and we own it as of the crown, meaning the crown holds the territory, and then we have this estate in it.
Okay, so fee simple. That gives us kind of a basic understanding of fee simple.
Fee simple is the largest estate that's possible to own in our common law system of property.
Right. Okay, so let's talk about the Cowichan ruling.
Yes.
Which directly addresses fee simple, and that has now been usurped, correct?
Yeah. Well, yes and no. So one of the many problems with what has happened, both in the ruling and by what the BC governments and federal government have done. Part of the problem is it's difficult to know now what the story is. So the key phrase in the Cowichan decision is prior and senior. The court said Aboriginal title, where it is found to exist, is prior and senior to fee simple title. Meaning that if Aboriginal title is found over the property where you own your house, that Aboriginal title is senior and prior, which suggests superior. That is, it is possible that you will have to give up your property interests to satisfy the interests of the group that holds Aboriginal title. But this is all in flux because, number one, the Cowichan decision is being appealed.
Yep.
And number two, in the Cowichan decision, although the court made this declaration, no private property was actually claimed in the case. And so none of it was actually awarded. But the court said, well, we find it to exist and it is senior and prior, but we're not going to move anything at this time.
Yeah,
right?
which has left property owners going,
and understandably
where does that,
so.
Yeah.
I mean, this means that the property that you thought was secure, beyond all question, it's there on the register. You're the registered owner. Everything is as it's supposed to be, and that what we now know is that you can look at the register and see that everything is still as it was, but it's not. Now there is an uncertainty that has been inserted into the situation, and people who own homes, especially in BC, but this applies also potentially across the country.
Yeah.
We just don't know now how secure that land is if you are in an area potentially where an Aboriginal claim could be made.
Okay, so let's pause there. Now let's jump to the Constitution.
Yes,
There is Section 35.
correct.
Explain Section 35.
Section
of the
35
Constitution
is
Act.
the section of the Constitution, which is not in the Charter, but it is in the Constitution, which guarantees Aboriginal rights, treaty rights, that existed as of 1982, existing Aboriginal
Right.
and treaty rights. Since 1982, the Supreme Court has interpreted that section in what I think could be called an expansive way. So the court has been finding things that have always been there. This is the part of the essential myth of how the law works in the courts.
Right.
So, for example, they determined that there was a duty to consult. That's a Supreme Court finding from a case involving the Haida that suggests that whenever the government is contemplating a development that might affect an area of Aboriginal claim, there's a duty on the part of government to consult with the relevant Aboriginal group before the development goes forward. And that has resulted in even more uncertainty because nobody exactly knows what the duty consists of and what is required, and it holds up development projects and makes things more expensive. And so if you combine these two things, and there are other things too, but if you just talk about these two, the duty to consult and the potential now for senior and prior Aboriginal title claims, now we really don't exactly know what the status of property is.
Do we want to add UNDRIP into this?
Oh, we do. Oh, we
So
do.
this is
We
the
do.
this is the United Nations Declaration on the Rights of Indigenous Peoples.
Yes.
We've heard about UNDRIP a lot, especially in British
We have,
Columbia.
and it's a big thing. But before we go on to UNDRIP, let me just add one thing.
Yep.
Section 35 is in the Constitution. Here's the thing that's not in the Constitution. There is no guarantee of property rights in the Constitution, in the Charter.
Right.
In the original draft of the thing that became the Charter, property rights were there. But they were
Pierre
taken.
Trudeau put that in,
Pierre
yeah.
Trudeau actually included
Yeah.
property rights in his original draft of what became the Charter. That guarantee was taken out at the request of some of the premiers. So in the version that was enacted in 1982, if you read it today, there is no guarantee of property in the Charter, but there is Section 35. So this is the constitutional problem.
Right.
UNDRIP is a different animal altogether. UNDRIP is a United Nations General Assembly resolution, 2007, I believe. A General Assembly resolution is really almost a legal nothing. I mean, it's not a treaty. It certainly can't be enforced in a Canadian court.
binding.
It's not binding. You vote on it, and originally Canada voted no, and since then we've changed our tune. and signed on to it. But
Right.
even so, you can't go to a Canadian court and say, there's a UN Assembly resolution, please enforce it. The court will say, well, that's not the law in Canada. So far, so good. However, in 2019, the BC legislature passed a statute called DRIPA, the Declaration on the Rights of Indigenous Peoples Act,
Right.
which essentially required the BC government to ensure that the laws of BC were consistent with UNDRIP. Now, what does UNDRIP say? It's an extraordinary document. It has pages and pages of rights and entitlements for Indigenous people, which are essentially unqualified. And one of those provisions basically says that Indigenous peoples have the right to any land that their ancestors ever used. And you think, well, this must be symbolic. This must be aspirational, and that's the way the document was described.
Right.
Right. They can't be serious. This is a symbolic thing. Okay. Except that now you have a BC statute that says the government must make sure that the laws of BC are consistent with what the Declaration says. And in 2021, the federal parliament did the same. So what you have now is a legal mandate for the BC government to go and make sure that what the UNDRIP says is carried out.
Now we go to Musqueam.
Yes. But the Musqueam Agreement is really just the beginning. It acknowledges the existence of Aboriginal title. And in fact, there are 3 agreements. The Musqueam are 3, but there's one that deals with title. It acknowledges the existence of title over this very large area, as you described.
Including Vancouver, yeah.
Basically Metro Vancouver, the
Yeah.
lower Fraser Valley. And that's basically the extent of it. It's like you don't know what this means. And presumably there'll be more to come to just try and describe what the implications of this are, or the details, or the rights that are involved, and so on. But as of right now, it's fair to say that the people who own property in this large area around Vancouver should be concerned that the federal government now is introducing an element of uncertainty about the nature of their property interests.
So now we go back to Cowichan. I know we're jumping around a little bit. So there's appeals
Yes,
that are happening with that decision.
correct.
And the appeals actually involve the Musqueam and Tl'uqtinus
Yes, well, one
First
of the
Nations.
funny things.
They've been left out of this. Is that what?
Well, so at the same time that Aboriginal title is claimed over certain territory, it sometimes happens that more than one Aboriginal group is claiming title over that territory, and so they are in competition, as well as the people who own private property. And this is what happened in the Cowichan situation. The Cowichan, the court said, are the ones that have title over this territory, and the other groups that you mentioned are saying, well, no, it should be us. So this is very contentious, not only in terms of whether or not Aboriginal title can be found over private property, but also between the Aboriginal groups, depending,
Right.
who have different stories about why it is that their body should be the
Right.
one to have found the own title.
So we have the different Aboriginal groups
Yeah.
that disagree. We've got landowners who are now more than a little bit in the dark. Do you believe when the First Nations and government are saying, "Don't worry about it. It's fine. We're not coming after your land. It's fine." And you said last night, I thought this was interesting.
Yeah.
You made the point that we are moving into an area where this is now government moving into land control and land, I forget the word that you used.
There's an old phrase, a man's home is his castle. And the idea behind that phrase was that the property that you own is a place that's yours. It's a barrier between you and the rest of the world. It's a place where not even the government can intrude. Your land is an asset. Your land is a protection. Your land is a sanctum. That is being broken down. And more, property is still an asset. It's still worth money. It's
Yeah.
still worth having.
Yeah.
But more and more, it is also becoming a liability, because governments have found ways to use it to raise revenue, to use it to control the use of land, to control the way the commercial activity in the society works, to create restrictions and limitations, and to require licenses and quotas and permits, and to require inspections. In other words, the managerial state that we have, one of the things that it does is to supervise your use of your property. So your land is not your castle anymore. Your land is now also their land. And they believe that the way you use your land, I mean, you still have a lot of rights and you still have the ability to decide a lot of things, but it is also a belief held by the people who run the managerial state that the decisions you make on your land also should be in the public interest in various respects. And this is the justification for all of the rules and the limitations and the taxes and so on that they are imposing upon privately held property. One of my favorite examples is empty home taxes that are being imposed in places like Vancouver and Toronto. I mean, just imagine this notion. You have bought and paid for your own piece of private property. You've decided that you're not going to be there for a while. Your local government has decided, well, that's not okay. You leaving your land unoccupied for a while means that they're going to tax you, to penalize you for doing that. I mean, that's an outrageous notion. But in 2026, we just accept that as one of the things that governments do.
So let's put a bow on this now.
Yeah.
So early in your discussion last night, you said in a free society, we either trade or we fight.
Yes.
Where are we headed? Where are we headed in this free society in which we live, and this particular issue of property rights, Aboriginal title, land rights? Where are we headed?
It's a very good question. It's hard to know right now, but it's becoming a real mess. But you know, in a way, we could say that it was inevitable that it was going to be a mess eventually, because what we have, we've made a category mistake in this country. And what I mean by that is we have been going along the way with a deeply embedded idea, both in the law and in the culture. And that idea is that people belong to one or the other of two different categories of people. That's a category error. I would put it this way. People are individuals. There's only one category of people, and they're people. Then they're all individuals.
Right.
When you start to assign people to categories, and you assign different rights and entitlements based upon what category you've assigned them to, you are heading down a very bad path. If you want to live in a free country governed by the rule of law and blind justice is this idea, as people may well know, that the law and the courts and the government should treat all of us without regard to who we are. You know, we have statues of Lady Justice wearing a blindfold. And the whole idea is she's not supposed to know who she's dealing with. She's supposed to take the laws and apply them neutrally with an even hand and not give fear or favor. We do the opposite with respect to Aboriginal questions. We say, well, who are you? You know, which group do you belong to? Show me your lineage. Show me your affiliation. And on that basis, you might have treaty rights, you might have title rights, you might have tax exemptions, you might have this, you might have that, but we're going to categorize you into a category. That practice, for my money, was bound to go wrong, and now it is.
So in your view, in your opinion, where is this going long term? Is this just going to be court case after court case and legal battle after legal battle?
It is going to be that unless somehow this country has the wherewithal to come to terms with the situation. And I don't see that happening. I think this idea is so deeply embedded in the way people think. We believe that a separate category of people called Aboriginal peoples is the natural and proper order of things. And to try and question that in a broad, politically acceptable way is going to be very difficult. And the alternative is, just as you say, it's going to be a long series of continuing court cases. These have been going on for a long time.
Yeah.
But we're reaching now a point where there's now conflict between private property and these claims. We should add, though, that most of Canada is owned by the Crown, not by private Canadians. So even if, down the road, the courts try and maneuver a way around the conflict between private property and Aboriginal title, there still remains the question about, well, even if Aboriginal title claims are limited to areas of Crown land, well, but a lot of Canada's economy is based upon activity on Crown land. Who's going to control that? Are we talking about Aboriginal control over the activity that generates the prosperity from Canada's economy? Is that what we mean? I mean, there are consequences that are going to follow from this, no matter the twists and turns that it takes.
It's been fascinating talking to you. I know we could likely go even a little bit longer, but we'll wrap it up there. Bruce, I appreciate you so much coming in and walking us through some of these things.
Sure, thanks, Rod.
Thanks so much.
Yeah.
Bruce Pardy is a law professor at Queen's University. He's also executive director of Rights Probe. Coming up on our special report on Indigenous land rights, we meet some homeowners on Vancouver Island who've been evicted by a First Nation. But this is on reserve land. So how is that different? Well, we'll answer that when we come back.